Welcome back. We're talking about RMCP. It's an acronym that is very well known in compliance circles. It is referred to as the Risk Management and Compliance Program. So on my immediate left, Germa, I'm going to start the ball rolling with you. What is it? Why is it necessary?
So the RMCP, in my opinion, is the most important document in your business to demonstrate to the regulator your compliance with the FICA, but also to implement a process in your organization practically to adhere to the requirements of the Act. So it's not only there to prove that you comply, a document that you create and file, but it's also a practical document that you actually supposed to use every single day and that everyone in the business should know and understand. Very important, this document is owned by the Money Laundering Compliance Officer. This is the person responsible to develop, maintain, implement this program. He's the owner of the program. He's also responsible to train the business on this document. So very important, who is responsible to develop and maintain this document. In the past, people used to think it's the role of the compliance officer. It's not anymore. So before the risk management and compliance program, we used to have a rules-based approach. Now it changed to a risk-based approach. So my advice is to apply your mind, but keep it simple. So demonstrate to the regulator how you interpret the Act. What do you do in your business to apply the rules and regulations that we talked about previously? Do not repeat the high-level definitions and everything that is required in the Act. Take each section, explain what it is, explain if it's applicable to you or not, and if it is applicable, how do you apply it to your business? Simple as that. Don't make it a 70-page MBA academic document that you do not apply in your business. Keep it simple, but keep it appropriate and applicable.
I think also what's important is that this is the FIC, Risk Management and Compliance Program, which is different to a risk management plan, which is one of the requirements of the FASE Act, but also is a general good to have risk management plan for any kind of business, which covers financial risk, operational risk, reputational risks, business continuity. Those kind of things are covered in a risk management plan of the company. The Risk Management and Compliance Program is specific requirement of the FIC Act in Section 42.
Yes, but I beg your pardon. Yeah. But there is a connection.
Correct, 100%.
Because the requirement in Section 42 is that the content of your RMCP must be aligned with the company's overall approach to risk.
And one cannot write it if you don't understand your business risks in general.
So to start off with your RMCP is you first explain your business, what you do, the background, who's responsible, who works there, what do they do, and why is FICA applicable to you. So when the regulator comes in an on-site, he wants to read that part of your RMCP to understand you and your business and how to judge the applicability of your document. The next step after that is to look at your risk rating, your risk matrix. What do you do? How do you determine the categories of risks that your clients fall into? Because that's basically the second thing that they ask for. A list of your clients with their risk ratings. So many people don't have this in place yet. They have an idea of how to risk rate and what to do, but they cannot provide a list of clients with the risk ratings, and that's a requirement within the Act. Chris, you wanted to add something?
Not at all.
Oh, not yet. Okay. Right, then after that, so you'll first explain your risk matrix, how you determine it. Then you will take that risk matrix and then explain how your customer due diligence follows from that. So for example, these are only examples. There's no hard and fast rule of how it should work. You need to apply your mind and determine how these...
You could have like a scoring matrix, or you could have a low, medium, high,
yes.
or If you're using a technological platform like Chris has, then it would compute a score
Yes.
based on multiple factors.
Yes. Then the outcome of that would determine your customer due diligence. For example, a low-risk customer, you could say that we only ask for a copy of the ID document. A medium-risk customer will ask for a copy of the ID and perhaps proof that he's paying tax and a bank account. It doesn't have to be an ID and an address anymore. It can be anything that you deem fit to determine your customer due diligence. Then for a high-risk client, you can have all of the above, plus an additional customer due diligence questionnaire where you ask him about the origin of his funds and background on his employment history and perhaps his political exposure, if applicable. So that will determine that then. Then following that, you'll have the rest of the acts in the sections in the act of the FICA Act. So you'll explain, for example, cash threshold reporting. You'll mention the section, mention what it is, whether or not it's applicable to you. If it is applicable, what do you do and how do you report it? What is seen as a cash threshold transaction? What is the format in which you report it and who reports it, by whom? So that is also explained in the document. Would you like to add something?
Yeah, I mean, the rest of the document can talk to the likes of the record keeping, how you will go about maintaining records. You can include, for example, the method in which you would conduct the due diligence as explained. But then if it was high risk and I needed to do more due diligence or enhanced due diligence, how would I go about doing that? That needs to be explained. What am I going to do? So the document needs to talk to the practical realities of what you're going to do on the ground. It's going to talk about upfront the due diligence, the ongoing due diligence, the enhanced due diligence. It's going to perhaps include the fact that you are using a system. So if you're using some kind of technological platform, it needs to allude to the fact that now I don't have a warm body person X who is going to do X, Y, Z. My system is going to do such, it's going to risk rate, it's going to spew out a report perhaps that says this. If it's high risk, I'm going to refer it to senior manager for approval. What is that process that you're practically going to follow? And when I then file it all together and I record keep it, this is what it's going to look like. This is what my risk rating form looks like, or this is the program that I've instituted. So it's a program, it's a step-by-step program of how I'm going to risk rate, conclude on due diligence before I enter into those transactions. And then there are things like I will not deal with anonymous clients, as an example, that you would include in your risk management program. I have left the responsibility of this to maybe not just the money laundering compliance officer, but it's actually these representatives or these specific individuals, that I've delegated an aspect to. Some include the list of, who are the accountable institutions and which schedule do I fall into as my business. Right up front, I am an FSP, or I'm a bank, or I'm a crypto asset provider, and that's why I fall into this act, and this is what I'm going to go and do. So it's quite a practical document. It's not a template. No.
And then it also needs to explain how the risk management and compliance program is implemented within the business and branches, if applicable. You need to explain how this will be rolled out to the rest of the business as well, and how training is provided. How do you ensure that every single member of your staff knows and understands this document and their responsibilities in terms of this document? Then it's also practical things like the accessing of the Go AML system. Who does that and on what basis and how often do they do it? That needs to be explained in this document. The lists that you use to scan your clients, how do you do it, who does it, how regularly is it done, and when is it done? And then it's very important that this document is also dated and signed off by senior management. I've seen many RMCPs that are perfect in every way, but they've never been approved or signed off. Then they fail the test, unfortunately. So it's very important that they are signed. Then the regulator was very kind, the FICA. They published a critical technical assessment document that provides an Excel spreadsheet with every section of the Act. It's almost like a checklist that you can use to check your RMCP against that list to ensure that every single thing is contained in there. which is also very helpful and very important.
Yeah. I think, if I may add something, is the RMCP is your internal procedures document, which explains how you discharge every single obligation that you incur as an accountable institution. And you must take care when you read the requirements in the Act, which is all of that's contained in Section 42, because the requirements are slightly different depending on which obligation you deal with. Because the risk rating of clients, in consequence of a customer due diligence that you must perform, is one of the most important ones, they pay specific attention to that. And just to give you an idea of the complexity that goes into the drafting of the document, and forgive me for reading this, but it says, it must enable the accountable institution to identify. So you must have, in respect of how do we identify risk? Assess. How do we weigh it? Okay? What rating do we attribute to it? Monitor. Is it moving or is it a stable risk? Okay? Mitigate and manage any particular risk. And then there are multiple categories and subcategories of risk. So it sounds like quite simplistic at first glance, but your comment about the checklist is extremely useful.
And also you could have a perfect RMCP, but it's not applied in your business. Then you fail the test again. So if you have that list, that checklist, and your risk ratings, they want to take a file of a client and see which category do they fall into and which requirements did you adhere to because of that risk category. So it has to be practical. The documents need to talk to each other.
Germa, will you allow me to just connect with one other thing that you said, which was the role of the money laundering compliance officer and accountability. And this generally gets business owners to perk up a little bit. In the old version of the Act, and when I say old, I refer to the pre-2017 version, where we had the risk-based approach. There was a specific role which was called the money laundering compliance officer. We still refer to it today, but it's slightly differently described and in a different section of the Act today. And the reason that that has changed is because in the old regime, all the accountability was shifted onto the shoulders of that compliance officer. Now that compliance officer has a role to play and must take responsibility for the drafting and maintenance of the RMCP, but the board of directors, or if it's a single owner business, then that sole proprietor becomes the accountable person. So if there's a board of directors, they haven't signed off on the RMCP or there are other breaches, they can no longer point the finger to the compliance officer. And they accept responsibility jointly and severally in their personal capacity. They can't hide behind the corporate veil either. So that's quite an important distinction.
Yes, thank you for that.
Yeah, and I think that that's exactly why when you go on as an accountable institution the first time to register, usually there has to be a complement of an ID of the person who you're appointing, but there's a letter or a resolution or whatever authority has been given by the board of directors to appoint person X.
And it's a role that has to be considered carefully, because it could be a senior person, but they don't have access to a bank account. How can you be a money laundering compliance officer without accessing bank accounts to view cash transactions, for example? So all of those factors need to be considered before appointing that person that's accountable.
And importantly, it's not your external phase compliance
Never.
officer.
Cannot be. You know?
Very fruitful conversation. Very important document. One of the most important, as you highlighted, Germa. I buy into that. Critical.
Please let me just make one last comment, if I may. We should have touched on it under who are accountable institutions and the obligation to register. Please be aware that it has been like this forever in respect of estate agents, that every branch of an estate agent, even though they are branches of the same company, has to register separately, okay, as an accountable institution. And the reason for that is because they may be located in a geographical area where there are different risks, and those different risks cannot be accommodated by the description of the risk rating in this RMCP, and that's why they have to be set up as separate accountable institutions. There is a public compliance communication out which now compels many other accountable institutions. I don't think it has been published. I think it's still in draft format, And if it isn't, then we'll put a caption on, you know, at the, that requires many other accountable institutions to now do the same thing. I know that attorneys appear on that list.
Yes.
I know that, for instance, I think that certain credit providers also appear on that list. So the requirement is that you must draft an organogram of all your branches and all your subsidiaries and things like that. And then you must determine on that organogram, okay, what the specific risks are. You may have an overarching risk management and compliance program for the group, but you have to have separate risk calculation methodology and everything.
You may add annexures for
Yes.
branches if that works
Yes.
for you. Yes.
But if you are an accountable institution named on that new draft BCC, you have to register separately every single branch.
And I think the one we picked up recently is also juristic representatives, because sometimes juristic representatives are entities, and you could have a motor dealer with another juristic, which actually happens to be a, you know, now falls fully as its own accountable institution and was previously only reporting. So one needs to just watch out for that and make sure that those are all now registered and have their RMCP in place.
Yeah, and for the non-financial services members of the audience, what a juristic representative is if you want to practice in financial services in South Africa, you have to get a license from the Financial Sector Conduct Authority. Then sometimes there are other companies that also wish to practice, but they are still waiting for their license or something like that. They then work under the umbrella of an already licensed entity for a temporary period of time until their own license comes through. That's what's known as a juristic entity, a juristic rep.
Thank you. This was a very insightful conversation. I think it was very useful.